Hello, and today I have the great pleasure of being joined by James Sage, partner at RWK Goodman, social care employment law specialist. He's going to talk to us today about some of the upcoming changes in the Employment Rights Act and how it applies to social care. Hello, James.
Hi, Giles. Thanks for having me.
Let's start. Maybe we can just give a bit of an overview of how we've got to where we are today. Well, what is the Employment Rights Act and what's happening?
Yep. So this started as part of the Labour government's reform of workforce practices, and which was part of the kind of Good Work plan that led to the Employment Rights Bill, which was between Houses of Parliament, for quite some time, trying to agree some of the kind of core principles of the different provisions. It's the biggest change in employment law in over 50 years. There are over 27 different provisions coming in, which are going to fundamentally change the working relationship between employer and employee and definitely rebalance things more in favour of the employee or the worker. So all of these changes that are coming in are to benefit the workers rather than the employer. And, there may be some secondary benefits for employers as well, but the primary aim is to give workers more rights. The Employment Rights Bill has been supported by a number of different consultations. So the government is consulting on the vast majority of the key provisions in this. So some of those consultations have already closed. Some of them are open at the moment, and some will be launched in the future. And this is the first provisions are being introduced, soon, and we're going to have all of the provisions as currently planned within the next kind of 18 months.
Can I just ask a point on that consultations piece? Because I guess from the outside looking in, it feels like it bounced between the Commons and the Lords for ages, and then it passed, and we've theoretically got this act, but it still feels like there's quite a lot of lack of clarity around what some of this stuff will actually mean and timelines and things like that. Is that all to be solved in this consultation process?
Well, so at the moment, you're right. The Employment Rights Act as primary legislation is just the headline details, essentially. So the kind of high level framework of what the changes are. There will be lots and lots of secondary legislation, which are regulations, which will set out the detail of how all of these different provisions are going to work. So for many of them, there will be the consultation around specific parts of those or the entire provision. So the government then can make a decision based on that feedback, what it wants the detail to be. And then the secondary legislation and the regulations will follow so that we then all know what exactly is going to happen in practice.
And so it may be a stupid question, but procedural point, that secondary legislation, does it need to go through Parliament again, or is it defined by these agencies that are created or something else?
Yeah, no, it'll be approved by Parliament.
Yeah. Right. Okay. And so 27 major points. I think we're going to go through some of the ones that we think are most going to impact social care providers.
Absolutely. Yeah.
But before we do that, there's a bit of a timeline to when this stuff happens, isn't there? Is there headline summary of when these changes come?
Yeah, there is. It has changed. Some of the different bits have changed over time, but of the parts that we're going to talk about today, which are the kind of key ones affecting care providers and the things they can start preparing for now. First one's coming in April, and then we're going to have a number of changes in October this year, and then a number more changes in January of next year, and then the kind of last one will be the Fair Pay Agreement, which a lot will be happening between now and then, but the first Fair Pay Agreement isn't due until April 2028.
Okay, so just over 2 years away. Yeah. And before we dive in, just emotionally, how do you feel about all of this? Is it going well, or?
I think it's going okay. I think that a lot of the providers that we work with, particularly those with internal HR resource, are already starting to plan how some of these things are going to work. And I think that's quite key. When we've got all of the regulations, there's going to be a lot. And for a typical SME provider, that's quite a lot to kind of wade through and understand. So I think the earlier you can engage with it and start to understand some of the kind of headline provisions so that you're familiar with that and then move into the regulations and the more detail to get to it, I think that's worth doing. But from what we're seeing, I think, to me, it feels like lots of people are engaging, but then obviously I'm in that position. It's my job and I'm having that conversation. There was a survey 6 months ago, which said something like 60% of care providers hadn't heard of the Employment Rights Bill.
Right.
So, I don't know.
Okay, great. And so of those 27 pieces, we think there's probably about 7 or 8 kind of like headline areas that are most going to be affecting care providers. So brace yourself, we're going to go through them. So the first on my list is changes to statutory sick pay. Can you just give us a headline summary of what that is and what's going to change?
So the key changes are that statutory sick pay is going to be payable from day one rather than day 4. So the waiting period is being removed. And the second bit is that there is currently a lower earnings threshold in order to be eligible for statutory sick pay. So you have to earn £125 a week to be entitled. That is being removed as well. So that will mean that people on lower hours and lower pay will be in scope for statutory sick pay for the first time. And the removal of the waiting days will mean that more people, significantly more people receive SSP than they currently do.
And do you think, and so I guess what's the impact on care providers on that one?
Well, obviously there's the cost implication. I don't know whether things are different in the social care sector, but there are reports which say that on average workers have 5 days of sickness per year. I think averages in social care could be higher because we know that sickness absences, can be a problem. But if it was, 5 days of absence per employee and all of those absences were 3 days or less, currently that's costing the provider no statutory sick pay. Going forward, that would cost, every day of those absences would cost the employer. And we did some modelling, and for a provider with 300 employees who had 5 days of absence, and all of those days were, less than 4 days, because most absences are short. In the new world, that's going to be an additional, I think, £35,000 a year. If you've got 1,000 staff, that's looking more like £120,000 per year.
Wow!
So and
that's not including potential change in behaviour of people potentially increasing their number of sick days, right? So I was talking to a CFO who was saying that they used to have a policy where they would voluntarily pay SSP from day one, or sick pay equivalent from day one. They removed it and it halved their number of sick days across the organisation. Now, whether that's a good thing or a bad thing or not, whether that means people are coming in when they're sick because they're under financial pressure, TBD. But I guess, there's the clear impact of having to pay for those first 3 days, but also the sort of unknown impact of what's going to happen to employee behaviour.
And one of the conversations I had was with an HR director was a concern that staff might start to report other absences which are currently unpaid, whether it's carers leave or dependents leave or other things, as sickness, because now that would be paid.
Right.
So that could alter the kind of figures and the cost as well.
And so there's going to be a theme to these questions, but is there sort of any action points for people to be taking right now on this?
Yeah, I think the main one is to review your sickness absence reporting policies and procedures, because, inevitably there's a greater risk that forced with that decision of whether they come in or not, now there's an increased risk that people won't come in. And so having robust kind of reporting procedures and systems for logging absence is going to be of increased importance. Contracts are likely to need to be updated as well, because the way that the SSP regulations work currently, which are based on your days of work, would need to change. That's probably a minor thing, but an administrative thing primarily. But I think the focus really needs to be on those absence reporting processes, and then what you do and whether the managers are properly managing the absence, because that it's all very well kind of having those reporting processes, and if you've got all that data but then you don't do anything with it because someone's having lots of sickness absence, then that creates a culture and that creates problems. So it's just being on top of the kind of management of the
return to work meetings and all that kind of stuff. Okay, super, very good. Okay, point number 2. We've got changes to essentially unfair dismissal time periods and potentially changes to compensation limits on that. What's the story there?
So originally unfair dismissal was going to become a day one right rather than the current 2-year period. The government's rode back on that, and that's now going to be a right after 6 months. That is a positive change, not only because it's a longer period than day one, but the proposal previously was to have this really complex statutory probationary period, and then 2 different systems of dismissal processes, which I think would have been way too complex and difficult for people to manage in practice.
What, sort of like inside probation and outside probation?
Exactly.
Okay.
So I think this is a much better option. And the other kind of related part, well, there's 2 related parts. One is that the time periods for being able to bring an employment tribunal claim are being extended. So
to what?
So currently it's 3 months, and there's going to be extended to 6 months. So that gives people more time to bring a claim. And the other element, which was introduced very last minute, was the removal of the cap on compensation for unfair dismissal. So currently there's a cap of a year's pay or £120,000, and that's going to be removed. I don't think that element is going to necessarily impact most dismissals, because care workers, for example, aren't going to be on that sort of pay. So it'll still be limited to their year's pay rather than the higher. But where it's going to have the most impact is around senior executives.
And one of the big concerns with this as well is, I guess, the potential increased pressure it's going to put on the tribunal system, because you're going to get so many more claims coming through. What do you think about that?
Yeah, and I think that is a worry, and that's certainly something that employment lawyers have been feeding through our kind of Employment Lawyers Association, been feeding back to the government, because at the moment the backlog is awful. We're having claims that are at an early stage now, some particularly in London regions, being listed for 2028, 2029.
Wow.
So sometimes it's 3+ years from a claim being issued to getting to a full hearing. A large part of this was because when they introduced employment tribunal fees, so a fee to bring a claim, there was a massive reduction, 80% reduction in employment tribunal claims. This was a number of years ago. A lot of judges were then retired from those posts. And then when the fees were removed, suddenly all the claims came back up and there weren't any of the judges to do it. And then that's just kind of been exacerbated over a period of time. So it is inevitably there's going to be more claims. So it is a worry that the tribunal system isn't going to be able to cope with that. And, there are regular recruitment processes for more judges, but it still, needs a pretty significant change to what we have now to be able to keep up with that.
But I guess if you're a care operator, obviously there's it's a much shorter clock, in inverted commas, to work out whether your relationship is going to work in 6 months, less than 2 years, and that makes it harder. But in terms of like the actual process you need to go through if you do need to dismiss an employee, that stays roughly the same.
Yeah, that will stay the same. So I think the kind of things that providers need to be thinking about now are the recruitment process. So making sure that's as robust as possible, because obviously there's a greater risk that when you do come to dismiss, they're going to have unfair dismissal rights, so taking on the right people. And then that induction and onboarding process is going to be of increasing importance. And then I think the role of the manager is going to really massively change. We know that managers have many different kind of responsibilities within the organisation, whether it's kind of the finance, the care, the people side. What we see is that often the people side gets put to to the background, because there's not an immediate response if, for example, a probationary review meeting isn't done or performance isn't managed, because you've got that comfort of the 2-year period before someone has unfair dismissal. With the 6-month period for unfair dismissal, that's going to radically change. And I think there's going to be a need, and certainly the providers that we're speaking to are working on upskilling managers and giving them more confidence on dealing with people manager issues, whether it's performance, conduct, absence, so that initial period can give people the best chance of succeeding in that role. So rather than not proactively managing it and then getting to the point where actually we need to bring employment to an end because it's not working out, really proactively manage it. And then you're in a much more informed decision as to, prior to that 6 months, whether employment's going to continue or not. And what it will also mean is that providers who have got a probationary period of 6 months will want to shorten that going forward, because you want to give yourself some leeway before people acquire unfair dismissal rights to bring a probationary period and employment to an end.
Sorry, can you explain that last point again? So you're saying explain that again?
Yeah, so if you have a probationary period of 6 months at the moment, if you get to that period and then you're doing the review, they've already got unfair dismissal rights.
For sure.
So you might want to bring it shorter.
5 months or something.
Yeah, so you've got a bit of leeway.
Okay. And do you think is there any risk that this could almost backfire on the employee or the worker, in that I guess managers might be more trigger happy to exit people early on in the relationship when there's a sort of a question about performance?
It's possible. I think it's possible. I think what you've heard more in the public is concerns about whether people will recruit. Obviously, that doesn't really apply in social care so much, because you have to have the people. But whether it will, I think it will be different for different organisations. I think there's a positive for employers, because if you can get that right, and if you can get managers more proactively working on that initial 6-month period, because we know that's when the highest levels of turnover happen in care, is in that first 6-month period. So if they can actually get those processes working much better, the benefit potentially for the employee and the worker is that there's less risk of them being dismissed, because actually they've been given the support and the things that they need to meet the requirements of the role. And then on the same time, the employer gets better retention rates.
Okay, great. So point number 3,
Yep.
changes to Refire and Rehire practices.
Okay.
What's going on there?
Yeah, so this is where an employer is looking to vary terms and conditions of employment. You'd normally consult. If the workforce don't agree, then potentially you can fire, you could go through a process of consultation, dismiss employees, and then offer them new contracts on the new terms. The government's manifesto pledge was to abolish this practice completely. This was kind of in response to the P&O ferries saga. They haven't actually gone that far in the proposals in the Employment Rights Act. So it's still going to be possible to kind of fire and rehire, but the legal test is significantly higher. So the employer would have to show that they're in financial difficulty, which is threatening the existence of the business, and that the change wasn't reasonably avoidable, which is a significantly higher test than now, which is just saying that you've effectively got a reasonable business case, essentially. So the realities are that it's going to become significantly more difficult to make those sorts of contract changes. This is definitely going to apply to pay. There's a consultation at the moment about whether it should apply to benefits and shift changes, for example, changes from nights to days or vice versa, or week to weekends. So it'll be interesting to see where that lands. But I think why this is particularly relevant is that we know in the wider context of the care market that employment costs are rising significantly. We had the national insurance contribution increases. I was looking the other day and realised that the national living wage over the last 5 years has increased 40%, and funding isn't keeping up with that. And so what you have seen over the last few years is some providers who have got enhanced terms, whether it's around sick pay or other things, looking to reduce those in order to keep things viable because the funding isn't keeping up with the costs. So if providers are in that situation thinking that's what they might need to do, then it would be a good idea to bring those projects forward before these new changes come in, because it will be much more difficult.
So this isn't just, from my understanding then, this isn't just about, you're a care operator that, let's say, maybe acquires a new service and is trying to, unify and centralize people's employment contracts across those. No, this is literally any change of, it has a downstream impact on any change of terms in someone's employment relationship.
And the situation you mentioned, so in all likelihood, where there's been a transfer of the business, there's going to be additional protection under the TUPE regulations.
Right.
But this is just any change that the provider wants to make to terms and conditions.
Interesting. So that is potentially quite a big impact on people.
Yeah.
Okay. So point number 4, third-party harassment and claims against that.
Yeah, so currently, obviously, employers are potentially liable if their workforce are harassed on the grounds of a protected characteristic by other employees. But there isn't currently a direct liability for harassment of your employees by third parties. So, and this is particularly relevant in care because some people might be running services where they've got very challenging service user needs, and so that does happen. There could be kind of abuse and harassment that sometimes service users or the workforce are experiencing from service users. So what the Employment Rights Act is going to do is it's going to introduce a new direct liability for providers and employers generally for harassment of their workers by those third parties. So it could be a relative, it could be a service user, it could be a third party contractor that comes in. There is a defence. So if the provider has taken all reasonable steps to prevent harassment, then they will avoid liability. So that means there's a load of preventative, proactive things that you can do, whether that's putting things in your contracts with clients or with third parties about their behaviours when they're on your premises, or whether it's putting signs up. You see, don't you, often in public spaces now, our workforce will not tolerate abuse. You see that sort of thing quite a lot. That's driven by this. Yeah, so those things are, signalling what isn't acceptable. Training for managers, training for staff, making sure that you've got robust procedures in place for raising and managing these concerns when they happen.
And what about, but it's particularly of interest, the service user point, because obviously a lot of people work in environments where they're working with residents, service users with really challenging and complex needs. What does one do there?
Yeah, well, it is challenging, and I think
you can't just put up a sign, presumably.
Yeah, well, you can have conversations, but I think
if you're working in a dementia care home or something, and someone's has very complex behaviour.
Yeah, or young adults as well.
Yeah, for sure.
I think ultimately you get to a point where you've done all of the preventative stuff, an issue then arises, and it's what is reasonable or what you're reasonably required to do in that scenario. And that's going to be very fact sensitive. You might get to a situation where either an employee is having to move to work with someone else, or it may be that you're in a situation where you're having to threaten a placement. So we would, in those scenarios, we would typically work with our regulatory team and try and balance out those kind of employment considerations with the kind of regulatory and contract situation with the client. But yeah, they can be tricky.
What's the potential downside to care providers if they fall foul of this?
So it's the risk of an employment tribunal claim for discrimination,
right?
From the worker, from the employee. So
similarly with an uncapped liability.
Yeah.
Okay, interesting. I mean, again, I'm just thinking about some service users I know of or I've worked with who, it would be very hard to take reasonable steps to limit perceived harassment from that person. It's kind of par for the course.
Yeah, I mean, sometimes the behaviour is because of a specific protected characteristic, and so it may be possible to put someone on working with that person who doesn't have that protected characteristic as a way of avoiding.
Is there a risk on that? Is there a sort of like opposite side risk of discrimination claim based on that? Like it's the case we get all this, we often sometimes worry about where, someone wants to work, a service user doesn't want to work with someone who has a different color of skin to them, for example. And that's what I find that quite, irrespective of this upcoming legislation, that's quite a difficult situation to navigate.
Yeah.
Anyway.
So you would hope, again, fact sensitive, you would hope that by moving them, you're solving a problem for them and respecting your third-party harassment duties, but obviously there would be a risk if that move meant that, for example, they
were less employed,
or they had to work in a different service rather than just in the same service with different client, or it had some other it impacted their shift, so they were put to a disadvantage as a result. Then yes, so you'd have to weigh those things up. Interesting.
Another huge piece of legislation that's going to be coming in is around an end to exploitative 0 hours contracts. I hear a lot of people talking about this because it's a very common model of working within social care, NHS, in fact, a load of different parts of the economy. How do you see that planning out? Yeah, it's interesting. I think I don't see it as being exploitative within social care. And I think that, the main reform is that if you're on a 0 hours or a low hours contract, there will be a requirement to offer that worker or employee a guaranteed hours contract based on their average hours over the previous 12 weeks. There'll be a requirement to give them reasonable notice of shifts, and there'll be an obligation to give compensation if you cancel shifts last minute. I think the impact of this will be felt very differently on the residential and the home care side of the market. So we have been asked over the years many times by residential operators to try and get more bank casual workers onto permanent contracts. So you've got a bit more certainty about what hours they're going to work. And almost always they don't want to do it because they want the flexibility and they're happy with how the arrangement works. Ultimately, if they wanted a permanent contract, they could have got one at any point because there's always a need. So I don't think it's there'll be an administrative aspect to it for providers in terms of making the offer. But and I suppose there might be some compensation if shifts having to be cancelled last minute, but I don't think that's going to be a big issue. I think the difficulty will be giving notice, because if you're using those casual bank arrangements to cover short-term sickness absence, how can you give reasonable notice? Because by their very nature, you just need to call those people in on the morning and say, someone's sick, we need you in.
So I think that will be difficult. From to cover holiday, I think will be easier because you've got more planning time for that. But I think sickness will be difficult.
And that giving reasonable noticing, the idea is saying, okay, so I am working a 0 hours contract. I've been assessed as wanting to have a guarantee of, let's say, 20 hours a week, and but offered 20 hours a week, and then I have the opportunity to then accept or deny that work, or
so once the obligation is only to make the offer of guaranteed hours, and workers can just reject it. So I think that for many in residential, that's all they do. The obligation to provide reasonable notice is for those who remain on a 0 hours contract. So if you reject it, and then you remain on a 0 hours contract, then the employer will have to give reasonable notice in that. And I think on the sick pay side, that's where it'll be difficult. On the home care side, I think that's where the challenges will come, because a lot of home care employees are on 0 hours employee contracts rather than casual bank contracts. And often that's not their choice. And often that's the provider is not able to guarantee hours because of the way that services are commissioned.
Can you just explain the difference between those two contracts quickly?
Yeah, sure. So a casual bank contract is typically where there's no obligation to provide work. There's no obligation to carry out work. It's generally genuinely a meeting of minds to do the work. And so that's what you typically in care, we say kind of a bank contract. A 0 hours employee contract is where someone's an employee. So they've got a continuous employee relationship and they'll be acquiring continuous service, but there's no requirement to provide any minimum number of hours. So just the main change from other employees will just be that there's no guaranteed hours within that contract. So they've got additional rights. They've got unfair dismissal rights. They've got family rights and other benefits like that. The employer also has more control over requiring them to work when they want them to. Whereas with a casual bank worker, you don't have that. It's generally both parties have to agree.
And you're saying that sort of like casual bank worker relationship, there won't be any changes to this, or?
Well, I think that's more common in the residential side. They're in scope for this, but I just think people are happy with that relationship, with that arrangement. They've entered it, wanting that sort of flexibility, and they've got the choice. They could be a permanent employee if they wanted to be. In home care, a lot of employees, the only option they're given is to be on a 0 hours employee contract, because the provider needs them to be available when they need them. But because work can fluctuate up and down, and because commissioning is more sporadic, the only option providers often feel they can offer is that 0 hours employee contract. And so I think a lot of those people would like to have the option of guaranteed hours because it makes it easier for paying rent and mortgages and things like that. So I think there'll be more pressure on that side of the market.
And where do you see the impact of this on care providers? So obviously there's an administrative burden associated with this. Actually, let's focus on that first. So I guess, there's a 12-week reference period. Is that defined?
Yeah.
That's been defined. So you have to check over a 12-week reference period the average number of hours someone's worked. How often do you have to go through that process?
We don't know that yet. So we'll find that out in the regulation. So we don't know whether that's hopefully it's not going to be too regular. It probably won't be just do it once, but it might be an annual thing.
Okay. But
hopefully it won't be every 12 weeks. Hopefully it won't be every 12 weeks.
Right. Okay.
That would be pretty difficult, I think.
And I guess then, so incumbent on providers to have the right systems and processes to be able to relatively easy extract that kind of information rather than having to go through large exercises to try and work out what that is.
Yeah.
And do we know what sort of type of notice you need to give?
We don't. I think there's an expectation that it might be double the amount based on how other legislation works in other areas. It could be double the amount of notice compared to the amount of time you're asking that person to work. So if you need them for 2 days, giving them 4 days notice, for example.
Sorry, can you explain that again?
Yeah. So if you need someone to work for 2 days, then you'd have to give them double the amount of notice. So 4 days notice of working that shift.
Oh, wow.
Yeah. Okay. Which, as I said, from a sickness, if it's for sickness cover, that's impossible. So I don't know how that will work or whether there'll be exceptions in that scenario.
And so when you think about things like, social care and NHS actually across the whole sector, there's been this increasing drive to go from agency staffing through to more bank workers and then perm workers. Do you think this is going to have an impact on that kind of dynamic?
Well, interestingly, agency workers are in scope for this as well. I would have thought that agency workers will not be interested in accepting offers of guaranteed work because they're with agencies for a reason and they want that flexibility, because otherwise they could go to a provider and have guaranteed hours already, I would assume. There's generally a shortage of workers and of people to fill hours. Do you have a different view on that?
Well, no, I'm just trying to work it out from the work side. So I think agency workers want flexibility, but they also want full employment, and they want to work as much as they can. And I guess if they're sort of being underserved hours, if they're not getting the shifts that they want to get, I wonder whether they would be incentivized to try and do this one. And I guess from the other side of the equation, like, if I'm an agency worker that wants to do more work and therefore likes the idea of a guaranteed hours commitment from my employer, to what extent if I take that on, do I then have to go and complete those hours when they're given to me?
Yeah, well, they would need. So that's what's, I guess, the nuance here is if you're currently an agency worker or you're a casual bank worker, so you're not an employee in either of those scenarios. By accepting the guaranteed hours, you're going to become an employee.
Oh, you actually become an employee.
Yeah, because that's the main kind of one of the core differences between being an employee and one of those other statuses. So it's almost certainly going to mean that you're an employee of the provider at that point.
Which obviously comes with some of the upsides of being an employee, but
also some of the constraints.
Which is that if you want these guaranteed hours, it's going to have to be Monday, Tuesday, Wednesday.
Yeah.
Okay, interesting. So another important point that's coming in is around the increase in trade union representation amongst social care workers. Tell us a little bit about that.
Yeah, I think this has the potential to be really significant and fundamentally change how things currently work. So the proposals are that there will be an obligation for providers to provide a written statement informing employees of their right to join a union. So in their contracts, that's not a big thing, but it's creating awareness. The second bit is that there are going to be new access rights. So trade unions will have the right to access workplaces with the purposes of representing employees or with a view to getting collective bargaining rights or other things. And so that provides quite an easy route in to trade unions to get a foothold before then potentially trying to get formal recognition so that they then can collectively bargain with providers.
And that right doesn't exist today.
It doesn't exist at the moment. And what's proposed is that there'll be a voluntary access agreement. So there are some rules around what those might look like. And this has been under consultation. But if a trade union approaches an employer and says, look, we want to have access, you could reach an agreement based on what that access would look like. So how often is it? Where is it going to be? Is it going to be online and in person? And all those sorts of things. If the provider says, no, we don't want you to have access, the union can apply to the Central Arbitration Committee, who can enforce an access agreement on the provider. So they're consulting over certain grounds where they might not force that. For example, if there's already a recognised trade union in that workplace. But it seems, based on the consultation, like it would be more difficult for the provider to resist that rather than than easy, really. So what that does is that it gives them a foot in the door. Then the unions will be using that as a way of getting more members, getting people signed up, paying subscriptions. And then because the third kind of part of the reform is changes to the recognition requirements. So currently, if a union wants to be formally recognised so that they collectively bargain every year over pay and terms and conditions, they would typically approach a provider either at a regional location basis or a kind of national basis if got multiple locations, and probably say, we think we've got good support amongst your workforce for our union. We'd like to enter a voluntary recognition agreement with you. If the provider says yes, enter an agreement, that would say, every year we're going to negotiate with you over these different terms. It's not a commitment to make any sort of enhancement or payment, but it's a commitment to negotiate.
Set the scope of the negotiation.
Yeah, and also to consult on certain things as well, which might be broader than just terms and conditions. And so that's fine. If the employer is happy to do that, they can do that, and there'll be a voluntary recognition agreement in place, and then they'll be tied to that process every year, which can take up a lot of time, particularly from a finance and HR team perspective, in going through those consultations and negotiations. If the provider doesn't want to do that, then they can refuse. But again, the union can apply to the Central Arbitration Committee for statutory recognition, which would then enforce recognition on the provider for a 3-year period. And the thresholds that they need to meet in terms of the amount of support they've got to get statutory recognition are being reduced quite significantly. So at the moment, they need 10% of the bargaining unit, so the workforce or the group of the workforce, to be union members, and a majority of the workforce to support recognition. The requirement for the majority of the workforce to support recognition has been removed completely. And the threshold of union members within your workforce or within your bargaining unit is currently 10%, but the regulations will give the government the ability to reduce that by down to potentially to 2%.
What?
Yeah. So significant.
So if 2% of your workforce are union members, then they'll be able to initiate this process of, wow.
So that gives a lot of power to a very small group of people potentially. And so I think that will be a dramatic change. I think the unions will be
Excited.
Yeah, they'll be looking to get more recognised providers. At the moment, the sector isn't that unionised. I think some of the really large corporates have recognised unions, and some of the charities do, but the vast majority of the market is not isn't unionised and don't have recognised unions. So I think the unions will be seeing this as an opportunity to get more income because the more members they can sign up, and to give them more negotiating power within the sector. But also, and we'll come on to talk about the Fair Pay Agreement, but the proposal at the moment is that unions will be the representatives of the workers for the Fair Pay Agreement negotiating body. Mm-hmm. And so almost to legitimise their position as being the workers' representatives, they need to have these more recognition agreements in place. So I think that will be a big driver. And there'll be the financial side. I mean, different people have different views on this. Some people have the view that they haven't got the resources to go out large scale and get more providers recognised. So I think it will be interesting to see.
Well, the unions don't have
the unions might not have the resources. In some ways, there's a time element to it because you think between them, they'd be quite competitive to try and get in to the providers because once you're in, you're probably in for a reasonable period of time. So you'd think that might drive things to happen more quickly. But I think it's in all likelihood they'll be targeting the largest employers first because that provides the easiest and quickest return on time and investment, and more people signed up. So I think that's where they'll start. But it'll be interesting to see how quickly they'll get down to the kind of more medium-sized providers.
And I guess if you are large, private equity backed care provider, you've got teams and expertise that can deal with some of these changes. Mm-hmm. I guess if you're a relatively small or medium sized, owner operator family business, whatever it is, probably quite scary, the idea of the union representative knocking on the door.
Yeah, I think it is.
Waving some paper and being like, this is what's happening now.
Yeah, and I think the prospect of having to negotiate pay and terms and conditions every year with a third party is not generally how people want to run their business. And I think that some of those negotiations can be quite challenging. Sometimes, there will be very different expectations. And part of that's the negotiation process, starting high with a view to get something reasonable. But that is quite a challenging process for employers. And it takes up a lot of management time and resource. So something they need to think, providers need to think about is how they're going to manage a approach from a union, because they need to get that relationship off on a good footing. Even if they don't want to have a recognised union, it feels like getting that relationship off on a good footing is going to be quite important, because if it is ultimately imposed on them, a better relationship is going to be fundamental to that not being a real headache. So I think...
So it's like proactively go out and try and find your favourite friendly union.
So it might be doing some research on who would they most like to work with out of the different unions, and who would they definitely not want to work with, for example. And
who's good and who's bad?
Yeah. And
who is which?
Well, I couldn't comment on that. That's probably not my position. And I think people have different experiences. And a lot of it comes down to the different trade union representative at a regional level as well. So it's mixed. Yeah. But what I would say is that I think those who find it constructive, having a recognised provider, they would say it's really, really about having a really positive, constructive, well-managed relationship. That takes quite a lot of time and effort, and often you have a designated role in the organisation who's going to be the main point, a kind of convener, who's going to ensure that that's working well. If it's not coordinated in a good way, then that is when the relationship and the communication can kind of break down. So I think providers need to be thinking about how they manage the approach initially, that's something they can start planning now. And also, what is their response going to be? Are they going to say, yes, this is something we're willing to discuss? Are they going to say, no, we are definitely not up for this? And so what are the alternatives in that scenario? And we've certainly been working with some providers who are looking at alternative ways of trying to prevent a union coming in and getting recognition. And one way to potentially do that is to put in place an employee representative body if you don't have one already. Because if you've got a kind of employee forum, that provides direct lines of communication between your workforce and your management team. And if that works well, then those employees might not feel that they need a third party to come in and potentially change some of the message and the dynamic and the directness of their relationship with the management team. So that might be a way of preventing that.
That's presumably, irrespective of any legislative changes, that's presumably pretty good practice to have anyway as an employer.
Yeah, it can be. Yeah.
To have that channel of communication with your staff.
Yeah.
Okay, it takes us neatly onto the fair pay agreement, which is probably the thing that I think care providers are probably most concerned about, maybe, because there's some very tangible cost component to it and how it's going to be funded.
Yeah.
Run us through the plan there.
Yeah, it is really significant because this is the first time we will have sectoral collective bargaining in this country. So it's a completely new concept from an adult social care perspective. And the kind of aim is for employer representatives and employee representatives, which would be the unions, to negotiate increased terms and conditions for workers using an allocated pot of money from the Department of Health and Social Care on an annual basis, with the kind of objective of improving terms and conditions so that recruitment and retention improves and that there's less need to rely on an international workforce, because we know that route is very much being shut down. So it's to kind of offset the implications of that as well. I think that providers are worried about it. But also on the other hand, at the moment, it feels like it's some way off. I think there's a lot that needs to be done between now and the first fair pay agreement in April 2028. Actually, that's after it's been negotiated and is taking effect. So the negotiating body needs to be set up. We need to agree who's going to be on that. They need to agree the parameters of that and all of the process. And then they're going to need, the proposal is there's going to be 6 months of negotiations, 6 months of implementation every year. So that has quite a lot of kind of knock-on consequences. There's nothing in the consultation document about how that's aligned to local authority funding decisions and how that impacts. And there feels like there needs to be a link, because if the provider's having to increase pay in terms and conditions, they need the funding to be there. For the first fair pay agreement, the government has allocated 500 million, which, based on their own impact assessment, if you increased...
It's about £350 per person or something.
Yeah, well, I saw it in percentage terms. I think it was less than 3% pay increase if you applied an increase to all care workers, for example. So of itself, that doesn't sound like that's going to dramatically change recruitment and retention. But each year, these fair pay agreements will build upon each other. So every year there'll be an increase and then another increase. And so over a period of time,
you might see a sort of ratchet.
You might see it ratcheting up, because 20 years ago, there was quite a big difference between the pay of a care worker and the pay of someone working in retail or hospitality. And that's just been eroded over time because of the insufficient funding. So we might go back to that point where things are different. One of the things in the consultation that was asking was kind of who and what should be in scope for the fair pay agreement. In terms of who, it's proposed that it would be anyone working in social care, adult social care only. There isn't a plan to introduce for children's at this stage, but that might come later down the line. It also applies to England. So there will be a separate fair pay agreement and a separate negotiating body for England, Scotland and Wales. So there'll be 3 sets of this. So that creates some interesting challenges for providers who are working across jurisdictions, and particularly those who are working near borders, because if you've got different pay requirements on one side of the border to the other, that could drive employee decisions as to where they're going to work.
And just at the most basic level, and I appreciate there's a lot of stuff to be ironed out, but at the most basic level, you would be going through this negotiation between these bodies that are to be defined with these representatives. Is the idea then that you would arrive at a sort of new minimum wage threshold that would apply to all providers
Yeah. So there's
just
possibly
flat across everyone, or?
possibly. So there's a number. So in the consultation, they've set out a number of concepts that could be in scope. So this, for the purposes of the consultation, all they're asking is what should be possible. Every time the fair pay agreement is actually decided, it could be any of those things or multiples of those things. But at the moment, it's just trying to decide what's kind of in scope. And within the consultation, they've got, like you say, they've got just increasing the floor rate of pay. So a rate higher than the national living wage that applies just to social care workers. But there could be other alternatives. So it could just be a percentage uplift on pay, or it could be a kind of pay scale. So it's based on a career development framework, more kind of NHS style. Mm-hmm. And there was talk of one option being a kind of one-off bonus, but I don't think that really works. That didn't work at all well in COVID when there was people on benefits and things. So I don't think that's much of a runner.
Would it ever impact? Would the scope ever be beyond just like base pay and impact on things like, I don't know, rest periods or holidays or any other kind of parts of people's employment relationship?
Yeah. So there's the kind of pay element, and then there's wider terms and conditions that are potentially going to be in scope. Based on the consultation, the things that are likely to be in scope are, and I don't know whether there'll be an exhaustive list in the regulations, but we'll wait to see. But the things that are in the consultation are travel time for home care workers, so a desire to pay an hourly rate for travel time rather than an increased rate for contact time, which is how the services are commissioned, just paying for contact time, and then offsetting that enhanced amount against the travel time. So there could be like the requirement to pay the minimum rate by an hour for travel time, which would significantly increase cost and isn't really aligned to how home care is commissioned. So that would be a fairly significant change if commissioning didn't change alongside it. There's also the proposal to include sleep-in shifts, which we'd kind of thought we'd done and dusted through years and years of MENCAP cases. But there's a desire from the unions, I think, and certainly in scope in the consultation, for that to also be subject to an hourly rate rather than it not being treated as working time and be paid at a lower rate. And then, yes, that other things include increased holiday entitlement, kind of enhanced sick pay above the, so kind of full day's pay for X number of days. And there was talk of kind of pension entitlements and things like that.
Fascinating.
And then there's a broader kind of employee benefits piece as well. So you would think that the primary target would be baseline pay in the first year or two to get that up. But then some of these other terms, I think, are, from the union perspective, are quite high on the list of priority. Certainly sleep-ins and travel time.
And is there a risk that we end up, it'll keep you busy, I guess, which is good, but is there a risk that you end up with sort of like, one sort of corpus of employment law over here and then a whole separate social care specific set of rules around, paying conditions?
So there will be different rules. I mean, there are kind of nuances now anyway. So, I mean, we specialize in the sector, so that's fine for us. But yeah, I think it won't be, it's going to be limited to terms and conditions. So that, but yeah, it will be different to the entitlements outside of the sector.
Interesting. And there's also a number of new bodies that are being created or merged together to kind of marshal and steer some of these changes. Can you just tell us about those quickly? Yeah. So what's going, what's staying? Yeah.
So, the Fair Work Agency is being set up quite soon, actually. I think that's one of the April changes. And that will take over national minimum wage enforcement from HMRC. And it will also be responsible for enforcing compliance with holiday pay, sick pay, and fair pay agreement pay. And that will mark quite a difference because it's basically going to align enforcement for holiday sickness and fair pay agreement pay with national minimum wage, which is quite different to how other things work. So currently, if you're non-compliant with the national minimum wage, when your HMRC issue a notice of underpayment, they calculate that, they identify whether you're non-compliant, but when they're calculating the amount you've got to pay back, it's based on the national minimum wage now. So that effectively builds in an interest payment that has to go back to the worker. And also there's 200% penalties on top. And that will apply in the same way to holiday pay, sick pay, and fair pay agreement pay. So there will be meatier compliance than there would be, for example, if a worker went to an employment tribunal and brought an unlawful deduction of wages claim. So I think compliance will, there'll be a bit more teeth to that than there currently is. The events that we've done so far on the fair pay agreement, I think the the biggest concern is around funding. Most people are really in favour of being able to pay more, provide better terms and conditions for the workforce, but so many rely on adequate funding that they need that in order to be able to pass that on. And I think that there are quite a lot of question marks as to whether funding will be passed on fully. The impact assessment from the Department of Health and Social Care is assuming that the full cost of the Fair Pay Agreement will be passed on to either the local authority, to the NHS through CHC funding, or to self-funders. So 31% funded by self-funders. Now, there's definitely a question mark over whether the self-funder market is going to absorb the full cost of passing on these additional costs. Certainly, as the increases to terms and conditions get more and more over the years. So I don't think you can take it for granted that it's automatically going to be able to pass that on, where you've got a cost of living crisis, people's assets are
for sure
being used more quickly because of the cost of care and things like that.
Just for clarity on that point, so we're saying that, let's say for simplicity, you run a service that's fully local authority funded. The idea would be, in theory, that increased cost of Fair Pay Agreement would be fully met by associated increases in funding. But if you conversely ran a service that was fully self-funder funded, no help is coming.
Yeah.
You've got to work that out yourself, basically.
Yeah.
Interesting.
But I think the challenge is that you'll have the funding envelope from the Department of Health and Social Care, so 500 million for the first year. That will be allocated to local authority areas. We don't know what the kind of criteria for that will be and how it will relate to the amount they're spending on social care, because it might not be directly related to that. And so I think there's a risk that this doesn't cover the cost of providers having to make those changes, and a greater risk that it won't cover the knock-on consequences of the Fair Pay Agreement. So if, for example, the Fair Pay Agreement is that the pay floor will increase by X amount, if as a provider you want to maintain your pay differentials so that there's an incentive for people to take on more senior roles and more difficult tasks, that's unlikely to be funded in the Fair Pay Agreement. And so if you are exclusively relying on local authority funding, you could see yourself being in a difficult situation. And obviously all of these additional costs are coming on top of the national living wage. So we know that national living wage is going to increase again by, I think, 4% or just under 4% in April. And it will increase again probably the year after. So at that point, when we get the first Fair Pay Agreement, if it is an increase in the floor rate, it's going to need to be higher than both of those additions. And so you can easily see how local authority funding increases won't be sufficient to match that.
Fascinating. So if you're a care provider today and you're just hearing about this or early in your journey on understanding the change to the Employment Rights Act, what are some of the tangible action points that you can be taking today?
Yeah, I think the first thing is to find a partner who can help you. You do not, as a provider, want to be reading the hundreds of pages of legislation. So find a legal or other partner who knows about this and can give you kind of practical insights on how this is going to impact you as a care provider. And then someone who can, support you with the detail when the changes actually come in. And then it's just thinking about how you can practically implement some of these things. So is it training that's the answer to this particular issue, or is it a change of process? So just starting to map those things out, which I think we've got enough information to do that now. So now's a good time to do that before we get all of the detail and things start coming into play. And some of these things have a financial implication. And so starting to map out and how you're going to fund that is a good starting point as well.
I thought the point you made earlier was very interesting about the burden that's going to place on like the frontline management. So as you say, some of it is just about, P&Ls and, the money it's going to cost. But a lot of this is going to fall on frontline managers in terms of like increased burden over, hiring practices, performance management, increased reporting requirements around, understanding sick leave and all these kind of things. Huge amounts going to fall on that frontline manager. Yeah. Is there any, good resource you could point them to, are there any good resources out there that can help people through this change?
I mean, the key really is for the provider and employer to be supporting them with the people management training and with training on, for example, on the 0 hour side, shift allocations and, those sorts of things. So I think Some of that can be done in-house and some of that can be done with external support. So someone who can provide training on people manager skills, whether it's managing performance or inductions and those sorts of things. But there's plenty of resources out there.
Great. And then the most immediate timeline at the moment is April 2026. Yeah. And what are the key changes that are happening then?
So the main one there is the statutory sick pay change. So that obviously has a financial implication. And so now is a good time to be looking at that sickness absence process, policy, make sure that's robust, update it before then if you need to, and just start modelling what the potential cost could be to the organisation over the next 12 months.
So on top of that increased requirement for manager training, to what extent do you think like systems and technology can help support care providers through some of these changes?
I think massively, because I think having oversight and data is going to be critical. So, you can use software to model what your additional statutory sick pay costs would be, but also for monitoring absence and being on top of that, not becoming too excessive, and what processes you might need to put in place as a result. I think that the reforms to 0 hours is, there's a lot of kind of systems that could be used through tech platforms to notify to trigger notifications for offering the guaranteed hours or for the amount of notice that has to be given for those shifts and those sorts of things. So I think that is going to take a lot of the burden off managers, finding those tools that can kind of implement those things for them.
I think that brings us to an end. So James, thank you very much for coming to talk to us today. It's been very informative.
Yeah, my pleasure. Thanks.